Many people think you need to be rich to have an estate plan. In reality, estate planning can work for everyone. In many ways, estate planning is the final step in our investment positioning and financial planning work. It's how you ensure your wishes and goals outlast you. Let's start by looking at what an estate plan is. An estate plan isn't something you do for yourself necessarily. It's something you do to protect your loved ones. It governs how you give away what you have, who it goes to, how it goes to them. Plus, it helps protect you and your children when you're most vulnerable. This includes making healthcare decisions when you can't, making financial decisions when you can't, and caring for your children if you can't. You might think you can give away your assets and protect yourself without a complete estate plan. Maybe you have a will and think you can stop there. But to truly protect yourself, you need a full estate plan. It gives you control, privacy, and peace of mind. Without an estate plan, the wrong person might make crucial decisions. Someone you don't want, from the wrong family member to a probate judge. Even if you have a will, it goes through probate, and anything that goes through probate becomes part of the public record. Black Panther actor Chadwick Boseman died in 2020 without a will, so his estate had to go through the probate process in California. The probate process took about 2 years to settle. Boseman's estate was initially valued at around $3.8 million. But after court fees, taxes, and other expenses, the final amount to be distributed was about $2.3 to $2.5 million. The settlement of the estate appears to have been amicable, with no reported disputes between family members. However, this is only sometimes the case. The lack of a will resulted in significant cost to the estate, estimated to be around $900,000 in probate fees and related expenses. And there was no privacy. We know the public details because he did not have a will. Assets that are in a trust bypass probate and stay private. Even if you know how important an estate plan is, many people put it off because they're young or unsure who they want to fill these crucial roles. But this can be a big mistake. Especially after the pandemic we just witnessed, you don't want to leave these tasks undone. An estate plan has some unexpected benefits too. Did you know that if your adult child has a car accident or gets sick while away at college, their doctors cannot disclose details about their health or care to you without a medical power of attorney or HIPAA disclosure? That's just one reason for someone as young as 18 to complete some aspects of an estate plan. We just talked about your estate going through probate, even if you have a will. But did you know that this process comes with a fee? Depending on your state, this can range from several hundred to several $1,000s. The cost can be even more significant if you don't have a will. When naming guardians for your kids, an estate plan gives you flexibility. You can name the first choices, then the second choices, and so on. This gives you flexibility if circumstances change, say your sister moves to another country, without you having to update your estate plan constantly. The main components of a trust-based estate plan are as follows. A will is a legal document that specifies what you want to happen to your assets when you die. As the name suggests, the executor ensures that what's included in the will gets executed. Next is a living trust, which you control while you're alive. You name a successor trustee who will handle the trust when you die. You also name beneficiaries, your spouse, kids, charities, etc. The best part is you can create stipulations in the trust. For instance, you can make your kids wait until they're 18 to access their money, or stipulate that a beneficiary can't claim their share if they have substance abuse issues. This document tends to be very long since it has to cover every 1 in a million eventuality, even though most will never happen. There are also a few documents to validate the trust, to move your assets into the trust, and other related matters. Next, a medical directive, which goes by different names depending on your state, essentially names a medical power of attorney. This is someone who will make decisions for you if you're in a coma or incapacitated. You can also document your wishes so that this person has a set of instructions. Finally, there's a financial power of attorney. If you are incapacitated, you don't just need someone to make medical decisions. You need someone to pay the bills, sign the checks, and use financial accounts. That person is your financial power of attorney. For practicality, the executor, trustee, financial, and medical power of attorney are often the same person. This might sound like a lot, but don't worry. We recently partnered with a firm making this process easy. First, you fill out online forms, much of which we can complete for you as we already have the information in our system. Second, you make high-level decisions about the topics we've discussed, such as who you want to get what, if you wish to restrict things, and so on. Then Encore Estate creates the legal documents for you. These plans are customized from templates that estate planning experts painstakingly created with years of experience working with local law firms to ensure every document meets state and local best practices. Everything is designed to optimize estate planning at a high level and should work with your financial plan. Third, you sign and notarize the documents. Finally, and this is the step people often don't complete, you fund the trust, which involves transferring the titles of bank and brokerage accounts, homes, and other property into the trust's name. These final steps are what make your plan official. As you can see, the system is simple and easy to use. Once we start, the process goes quickly. We will send you a questionnaire before we get on a Zoom call. Then you watch as we do all the work on the system. The hardest part will be thinking through the big picture questions beforehand. We'll need to ask you some legal questions. For instance, what happens if one of your beneficiaries dies before you do? What do you want to happen to their share? After filling out the information, you'll receive documents to review. This can initially seem intimidating, as the trust documents can be more than 50 pages to cover all potential eventualities. However, each document comes with a guide. There's a high-level overview explaining what you need to review and sign, including what needs to be notarized. Some summaries explain what each document in your packet is. Next, follow the instructions on your review page and sign and notarize everything. We will provide instructions on how to work with a notary locally, or we may be able to provide access to one. Remember to notify the relevant people. Big decisions and paperwork can seem daunting, especially when combined. So we want to take a minute to emphasize the positives again. By creating an estate plan, you gain freedom. You take ownership and make choices, staying in control. When you make an estate plan, you have a say in your future. While a financial plan can help you get where you're going now, an estate plan ensures this planning and wealth outlasts you, and that you can help your family reach its goals even if you aren't around to see them. And finally, more than anything, estate planning is a tool to protect the people you love. It leaves a legacy for them, but also protects them and provides for them if something happens to you at a time when they'll be at their most vulnerable. Before we wrap up, we need to cover a few details. First, we must emphasize that we are not attorneys and cannot provide legal advice. We facilitate this service because we have seen how devastating the unexpected incapacitation or death can be when you don't have a comprehensive estate plan. We've seen sound financial plans blown apart after an unexpected death without an estate plan. And we have seen what can happen when a loved one is in a coma and her family does not have access to her accounts or health insurance. Often the family, even a spouse or an adult child, does not know what your wishes would be as far as pain management and life support. It tears families apart at their most vulnerable time. We want our clients to avoid that. Neither our partner nor we serve as your attorney. We can and do share legal information through this process. We also help provide context as we build your plan. A primary estate plan costs $2,500, but for existing clients, the cost is only $550 since we know the estate plan's role. Retitling your house into a trust and updating a current estate plan are billed separately. If necessary, we can discuss these potential costs on a case-by-case basis. Each estate plan is state-specific. Encore Estate Plans works with attorneys in each state and has a team of veteran estate planners on staff to review documents. Ready to get started? Email David or call our number and tell the receptionist you are calling about an estate plan. Thank you.